Let's go on the record on cause number DC 212822 Munoz versus Pio Kana et al. Counsel, make your appearances.
Judge, this is Mike Lee appearing for plaintiff. The plaintiff is ready.
Pete Smith, attorney for the City of Farmers Branch, and Amy Picuana, we're ready.
Earl Nesbitt and James Palomo on behalf of defendant Michael Scarpello, as elections administrator, in his capacity as election administrator for Dallas County, Texas.
And this is also Victoria Thomas, Your Honor, for the city defendants with Mr. Smith.
All right. I saw that Mr. Lee had submitted some exhibits, I believe, to the court reporter and to the court coordinator. What exhibit numbers are you offering at this point, Mr. Lee?
Judge, first of all, we have a court's exhibit 1, which is stipulated facts. And then plaintiff has plaintiffs 1 through 6, which plaintiff will be offering.
Is there any objection to plaintiffs 1 through 6 so we can kind of get this done?
No objection by city and Picuana.
No objection on behalf of the election administrator, Your Honor.
Plaintiffs 1 through 6 are admitted. Is the stipulation court's exhibit 1 been agreed to by the both defendants?
Yes.
As Your Honor,
Yes.
it's signed by all parties.
Okay, can I just so it's clear on the record, can I have each of the parties individually say that? So anyone for Farmers Branch, do you guys agree to the stipulation?
Yes, Your Honor.
Does Dallas County agree to the stipulation?
Dallas County election administrator is in agreement with stipulations of fact.
And plaintiff agree to the stipulation?
That is correct, Your Honor.
Okay, I don't think I saw the stipulation, so if you want to share screen it or whatever you want to do, I don't. But let's go ahead and.
Your Honor,
Do the defendants have any exhibits?
yes, Your Honor. This time we move for admission of the defendants exhibits 1 through 3.
Any objection to which defendant? Is this joint exhibits by all defendants?
It's the City of Farmers Branch and the City Secretary, Amy Picuana, but they're labeled as defendants exhibits 1 through 3.
Any objection to defendants 1 through 3 by the plaintiff?
No objection to defendant cities 1 through 3.
Defendant election administrator has no objection to Farmers Branch exhibits 1 through 3.
A defendant Farmers Branch 1 through 3 are admitted. Have you already supplied that to the court reporter, those exhibits?
I did. The answer is yes, Your Honor, but it was in a 12 megabyte email, and I'm afraid some of them didn't go through, just like the stipulations of fact may not have gone through.
I saw your other exhibits, but I was asking actually the defendant's Farmers Branch. Did you guys send your exhibits to the court reporter?
We did not because Mike had sent those in yesterday. So.
Oh, did you send both sides exhibits in, Mr. Lee?
I did, and
Okay.
courts 1, the stipulated facts, all in one body.
Tony, did you get all of those?
I did see the email, but I did not open them up. So
Okay. Well, if there's a problem, Tony will reach out to Mr. Lee. All right, let's go through the stipulated facts. I'll just read them. Okay, I guess 2F I'm not clear about. Are those facts stipulated or?
Your Honor, there are 2 areas in which we couldn't stipulate to specific facts, so what we did was stipulate as to testimony. One of them is 2F, the other is 12A and B,
Okay.
where we say what witnesses would testify if called. And I'm requesting, I believe Mr. Smith is joining in this request, and I don't think Mr. Nesbitt has an opinion, that the court consider that as testimony, what is in 2F, 12A, and 12B.
That's correct, Your Honor.
Okay. So no objection to me considering that as testimony by any party, is that correct?
No objection by the city defendants.
No objection by the election administrator.
And none by plaintiff, of course.
All right. Okay, keep going up. Okay, keep going up. So 12A is the issue.
And 12D, they're competing, to a point, competing versions of testimony.
That's correct.
Okay. Wait. You're going a little too far down. Okay, keep going down. Keep going down. Okay. All righty. Sounds good. I don't know that you need to call any witnesses, but Mr. Lee, go ahead and call your first witness if you have one. Or did you want to make opening statements first, or did you want to go straight into testimony?
I'd prefer to go straight to argument. Other than introducing my client, Ms. Munoz, who on my screen is on the second row, third over with the name Ikeda. Ms. Munoz, would you introduce yourself to Judge Hoffman? Oh. Obviously, the microphone didn't work, but
that's all right. That's all right. I met her the other day. So let me ask this. There's a couple questions I have then. I'm sorry. Anybody want to call any witnesses at this point? Mr. Lee?
I'm ready to rest and close.
Mr. Nesbitt?
We don't have any witnesses to call. We do have some argument. I don't believe our legal arguments were on the record the other day, so we're going to have to repeat those.
That's fine.
The
So
case-
you rest and close then, Mr. Nesbitt?
Yes, sir.
Mr. Smith?
Yes, sir.
You rest and close?
Yes, sir.
Okay, let me one thing I do want to see real quick is, can I see the exhibit with the application? I'm trying to remember the exact wording of what it says in terms of the number of months or how that's worked.
This is plaintiff's 2, Your Honor, and I've got the form with highlights also.
Okay, and then take me to the footnote again. Okay, go to the next page.
That's the final page.
Okay.
The other 2 pages in the document are in Spanish, and we intentionally did not.
Okay, I appreciate that. All right, let's go ahead and hear final argument.
Your Honor, may it please the court. For starters, let me address what is not before the court. What is not before the court is a substantive challenge to the qualifications of Ms. Munoz to be a candidate for to serve as a city council member, Council District 5 of Farmers Branch. That is not, number one, that's not the challenge. That's not the reason given by the city for her removal from the ballot. But we have stipulated fact number one, that under state law and the city charter, to be eligible, the individual must have lived continuously within Texas for 12 months prior to the May 1.
Within Texas or Farmers Branch?
The lived continuously for 12 months is a state of Texas obligation.
Okay.
The lived continuously within City Council District 5 for 6 months prior to the May 1, 2021 election is something that is in state law and is in the city charter at 2.02, Article 2.02. The lived within the city of Farmers Branch for at least 1 year prior to the date of the May 1, 2021 election is contained in the city charter.
Okay.
So those are the qualifications. In addition, there are the statutory qualifications that that weren't addressed in stipulation, but you must be more than a certain age, a U.S. citizen, a registered voter, not been convicted of a felony. She meets all of those. Those are stipulated. The testimony before the court is that Ms. Munoz has lived continuously within the state of Texas for 12 months prior to the date of the May 1, 2021 election. So she meets that eligibility requirement substantively. She has lived continuously within City Council District 5 at 3129 Golden Oak, Farmers Branch, Texas for 6 months prior to the May 1, 2021 election. So she meets that state law and city charter requirement per the testimony, and that she has lived within the city of Farmers Branch at 14038 Tanglewood Court, Farmers Branch, and at 3129 Golden Oak, Farmers Branch, Texas for at least 1 year prior to the date of the May 1, 2021 election. So she meets that city charter element based on the testimony. But beyond that, the city did not raise a substantive challenge. They raised a facial challenge. So that is what we have before us. And I want to address first and foremost the facial challenge as to residency. I'm looking at plaintiff's exhibit number 2. The question is, and this is in accordance with state law, length of continuous residence as of the date of the application sworn in the state, 37 years. Facially, that meets the 1 year minimum requirement. And in the territory from which the office is elected, that meets the both the state law statutory obligation and the city charter obligation of 6 months when she put in 7 months. So facially, this is in compliance with the state charter. The argument has been raised that that should have been a year, but I can show the court that that cannot be the case because the city charter does not require continuance residence of 1 year. And if that were the case, then the word continuous would not match with the city charter requirement. Going back to the elements of or the requirements for serving in the office and to be a candidate, it is lived continuously within Texas for 12 months, lived continuously within City Council District for 6 months, and lived within the city of Farmers Branch. To take the argument that that should have read a year or more continuous residence in the city does not match up with either the state law or the city charter, and therefore I'd say it is, I would argue to the court that it is clear that this is facially compliant with the statute and charter requirements. I also would refer the court to plaintiff's exhibit number 6. The footnote to that section says this refers to the length of residence inside the district or territory from which the office is elected. The district is District 5. Ms. Munoz swore to a length of residence continuously within the district, which is in compliance with the city charter and with state law for 6 months. And therefore she is facially eligible on the basis of this application. The application is facially compliant with the statute and with the city charter on the residence issue. The second point is the issue of the verification or the swearing to of the application by Ms. Munoz. I first of all refer the court to the candidate packet issued by the City of Farmers Branch, which is plaintiff's exhibit number 1. And I refer the court to page 4, which is a letter from the city secretary saying, and I'm putting my my cursor over because I couldn't get this to highlight, you may complete the form without the signature and I can notarize it for you when you file your application. That was direction by the city secretary. In fact, what happened based on the stipulated facts and as evidenced facially by plaintiff's exhibit number 2 is that Ms. Munoz signed the application before a Valerie Hawkins, who is an administrative assistant within the city secretary's office. Ms. Hawkins signed the application as for the signature of the officer administering the oath. And over here on the right, based on the stipulated facts, Ms. Piucana, the city secretary, affixed the seal of the City of Farmers Branch to the application. The argument has been made in plaintiff's exhibit number 5, which is the letter rejecting my client's application for a place on the ballot issued on February 16, 4 days after the close of the filing period, that the oath was not signed by a notary public, claiming that this is required by election code section 141031. And then it says in the note down there, after B saying sign, it must be signed and sworn to by the candidate by a public notary. The oath must be administered by a person authorized to administer an oath under Texas law. And then it cites the section 602.002 of the government code. Your Honor, my client was in compliance with both the instructions of the city secretary and therefore the city.
How so? So my understanding is that she went there, signed it, but did not get it notarized. How is she in compliance?
She is in compliance because she signed it before an officer administering an oath under Texas law. And I can refer the court to government code 602.002. Government code 602.002, I put up on the screen. An oath made in Texas may be administered and a certificate of the fact given by subparagraph 16, the secretary or clerk of a municipality in a matter pertaining to the official business of the municipality. It doesn't have to be a notary public. It can be any officer authorized to administer an oath. And lest there be any doubt, plaintiff's 6, which is the form application, down in footnote number 4, says all oaths, affidavits, or affirmations made within this state may be administered, and a certificate of the fact given by a city secretary for a city office. Now, I'm not sure whether or not the legislature intended for administrative assistants to be that person, but it does say clerk of a municipality in a matter pertaining to the official business of the municipality. What we've got is she signed it before a clerk in the city secretary's office, who signed as the officer administering the oath, and they affixed the seal of the city. The city secretary's office thought that was until 4 days later, thought that was a proper oath. I believe it is under section 602.002. In any way you slice it, Ms. Munoz complied with the instructions of the city secretary, who then, the very next day, after she signed it, said, I've reviewed your application and petition to run for Farmer City Branch City Council, District 5, and have accepted it. Now, this is after the city secretary, in compliance with 602.002, has affixed the seal of the city of Farmers Branch to the application, and then the city secretary accepts the application. That wasn't a mistake. It wasn't an oversight, because we have a stipulation that says that Ms. Piucana affixed the seal of the city secretary to that application. And for the record, she didn't do that to anybody else. The others had notary seals instead. This was properly signed, sworn to by Ms. Munoz before a clerk of the city secretary's office. The city secretary's office then affixed the seal. It was properly signed. It is proper as to form in all respects, and my client therefore should be placed back on the ballot.
Okay, Mr. Smith.
And I've got one fallback argument, Judge, and that is 7 hours and 29, if there was a mistake, 7 hours and 29 minutes before the end of the filing period, this acceptance letter was sent out. If there was a mistake, if it was not facially compliant, if that is the state of the law, I don't agree that's the state of the law, but if it is, then Ms. Munoz is entitled to at least 7 hours and 29 minutes abate and cure process by this court. I refer the court to N. Ray Francis. It is 186 Southwest 3rd, 534. This is one of the cases that came out of the mess that happened in the filing periods for the 2006 primary elections. And I have highlighted large portions of the Supreme Court opinion, but I'll jump straight down to the holding, which is right here. The holding is that we hold that when a challenge is made based on facial defects a party chair overlooked and approved when they could have been cured, the trial court must abate the challenge and allow the candidate that opportunity. Candidates should have the same opportunity to cure as a proper review before the filing deadline would have allowed them, consistent with the purposes of the election code and gamble. facial defects should exclude a candidate from the ballot only when a proper review by the party chair would have led to the same result. This involves a filing with the party chair, not with the city secretary, because it was a filing for in a primary ballot. But the holding of the Supreme Court would be the same if we simply substitute city secretary and party chair as the individual receiving the application. Ms. Munoz, at a minimum, is entitled to 7 hours and 29 minutes from whatever court's decision is made. If the court decides that it had to be signed before a notary rather than before a clerk of the office, then she should be entitled to 7 hours and 29 minutes to bring down a notarized application that says the same thing. Anyway, we slice it or dice it, Your Honor. Alita Munoz is a qualified candidate. Substantively, facially, she met all applications, and the Supreme Court laid out for absolute certainty in Ray Francis that we are not going to kick individuals off the ballot for facial defects that can be cured, and this is one that can be cured. We ask that the city be enjoined from conducting the election without including Alita Munoz as a candidate for Council District 5, and I'll reserve any remaining time for rebuttal, Your Honor.
Mr. Smith.
Thank you, Your Honor. May it please the court. We worked long and hard yesterday on stipulations of facts, so we have no live witnesses today. And this truly is just two questions of law for the court after you've had an opportunity to look at all the stipulations and the supporting exhibits. I did want to initially clarify one thing that Mr. Lee said. In stipulation of fact number 1 indicates what the state law and charter requires. State law requires a year in the state prior to the date of election. The city charter by state law is allowed to have and does have at the candidate must have resided in the city for 12 months prior to the date of election, and also provides that the candidate has to reside in the district for at least 6 months prior to the date of the election. So Mr. Lee says it's not a substantive challenge, but what you should know, Judge, is that the city secretary is the local election official that performs a ministerial function in the review and acceptance of applications for a place on a ballot for election to city council. If the application is complete, notarized, and appears regular on his face, and the face shows the eligibility requirements, then the city secretary accepts the application. The state law requires the use of the form that is promulgated, and in that box which you have seen, it says the length of residence in the territory and the district from which the person seeks election. So since the city of Farmers Branch has single-member districts except for the mayor who's elected at large, Ms. Munoz, who is running for District 5, was required to indicate that she resided in the city for at least 12 months prior to the date of election, and indicate that she resided in the district for which she sought election, District 5, for at least 6 months prior to the date of election. Ms. Munoz, to get on the ballot, was required to submit an application, which also includes a petition, which is not included because it's not germane to the issues at hand. She did timely file the application petition with the city secretary. You've heard the Mr. Lee discuss, and it is shown by the stipulation fact there was some confusion about the notarization. Ms. Hawkins, is the administrative assistant, is a person that sits at the front door to the city manager's office, and without being demeaning, she's a clerk, a secretary, not an administrative assistant in the sense that you might think of an executive assistant to some official. She didn't have the title of assistant.
Mr. Smith, let me ask you a question, because Mr. Lee cited to provision said city secretary, and maybe you can pull this up, Mr. Lee, or a clerk, I think, of the municipality. I don't remember how that was worded exactly.
I can resolve that for you real quickly, Your Honor.
Okay.
The city secretary is kind of, I would call it like the common law or the generic name they give to the city secretary of these cities, but they're actually, their title is clerk of the city. So
Okay.
the statutory term is usually clerk or municipal, or the municipal clerk or the city secretary. So a clerk of the city, in the context of the statute which you have before you, doesn't mean an administrative assistant who happens to be sitting there. And it's unfortunate because there was some confusion apparently between Ms. Munoz and Ms. Hawkins. The city secretary was out that day, and another lady, Ms. Egan, who's referenced in the stipulations, who had notarized all the other applications, was not there that day. The city secretary, Ms. Picawana, her notary seal had expired and she was waiting for her new one. And that's why the other lady in the office, Ms. Egan, had notarized all the other applications, but she wasn't present that day when Ms. Munoz came in. Ms. Munoz came in, she was asked, has it been notarized? Ms. Hawkins called the city secretary on the phone and says, I have an applicant here who wants to submit her application, and asked her to ask Ms. Munoz, and she and Ms. Munoz even may have got on the phone and asked if it had been notarized, and the answer was yes. And there's where we disagree on some of the facts, and that's why you have the competing testimonials in item 12. Without debating that, it wasn't notarized, and Ms. Hawkins.
So, Mr. Smith, let me ask you a question, because it says secretary or clerk of the municipality. Are there any cases that define what that means exactly? Because I get city secretary. I used to do some municipal law when I was in private practice. I've dealt with this issue before, so I understand what a city secretary is, but I've never heard of a city clerk. I know that there's a county clerk, but there's not a city clerk. So why would the legislature use two different terms there, secretary or clerk, unless they meant somebody who worked for the municipality? Because it says clerk of a municipality in a matter pertaining to the official business of the municipality. I kind of find Mr. Lee's argument fairly persuasive on that point, that this person would qualify as a clerk unless there's case law that defines that, and there may be a more archaic term.
Judge, could you excuse me just for a second? My Rumba has just come on in the other room and I've got to turn it off.
The problem with Zoom trials. Well, my dog is sitting right next to me, so hopefully he won't start barking. He's pretty good when he's in the room with me usually.
I apologize. So I think Victoria's looking as we speak right now so we can get a definitive answer, but the term has been municipal clerk and it's interchangeable with city secretary. An administrative assistant is not the municipal clerk of the city charged with all that official business. But if I can go ahead and continue while Victoria sees if she can find something definitive for you on that issue.
I will say that I mean, based on and of course I'll hear all arguments, but I think to me that's the most key issue here is, was this person an appropriate person who could sign this or not?
I don't disagree. That's why I say it's really two questions of law, whether on the face of the application, it had the right residence requirements, and whether it was notarized or there was some exception to the typical notary. If Ms. Hawkins was not a notary, and so that, and it's undisputed that it wasn't notarized, and Ms. Hawkins wasn't a notary, although Mr. Lee has offered some exception, being the clerk of the city. In any event,
Your Honor, what I have found so far is in the election code 1.005 says city secretary includes a city clerk, or in a city that has no city secretary or clerk, the city officer who performs the duties of a city secretary.
and there's no evidence that Ms. Hawkins performs the duties of the city secretary.
Okay.
So, and it's indeed unfortunate because Ms. Hawkins, not familiar with that form, called the city secretary, and Ms. Munoz thought she had notarized it and then later said, depending on which testimony is you follow. Be that as it may, it's undisputed that it wasn't notarized. On the face of the application, it shows 7 months. The city secretary contacted the Secretary of State for guidance on the application, both on notary and on the residence requirements, and got email responses back. And those are included in Defendant's Exhibits 1 and 3, I believe, where you can see the city secretary relied upon what the Secretary of State had told him, said, no, it has to be notarized. And 2, it has to show, if it said 7 months, that was not adequate. And I know that's subject to dispute about as a matter of law by Mr. Lee. Nonetheless, the city secretary, acting in good faith, was following the guidance from the Secretary of State. She sent out two rejection letters to Ms. Munoz, who got those and understood the problem. The other thing that I want to point out is that it's not the responsibility of the city secretary or the city to assist candidates for election to complete their election forms. Granted, there's no dispute about the pamphlet that the city provided for candidates as information and to assist them in the process. Nonetheless, completing the application for a place on the ballot and the petition is a personal obligation of the candidate. And that obligation to ensure that it's properly completed, notarized, and timely submitted is the obligation of the candidate and can't be shifted to the city secretary or to the city for obvious reasons. I wanted to also mention that Mr. Lee mentioned this cure period. They have not, as of this date, made any effort to try to cure the notarization and or the residence requirement in that box on the application form. So those are really the facts. They're undisputed. It's 2 questions of law for the court. 1, was it notarized, or was it notarized by someone who had the authority? And 2, whether the application form on the box for residents in the territory or the district was correct.
All right, so I need to take a quick break. Mr. Roman and Mr. Paloma, are you here for this case or something else? Are they here for this case?
Hello, I'm the treasurer for Alida Munoz's campaign. I'm just
Okay.
here for observing.
Okay, Mr. Paloma.
Judge, I'm here for this case on behalf of Dallas County.
And
He's my
Mr.
co-counsel, Your Honor.
Okay, Mr. Onamisi, or Miss Onamisi, what is she here? Is she here for this case?
I think
muted.
she's an observer also like Mr. Roman.
All right, I'm going to take a quick break. I'll